Thank you. Okay, so the state has closed their case, correct?
That's correct, Your Honor.
So now what's going to happen is Mr. Crane is going to have an opportunity to open his case, and you're going to hear defense's side. And then the first person he's going to be introducing is going to be Deputy Bauman. So we're going to get him right now. And again, this is the start of the defense case. Hi, how are you?
Good.
Swear to tell the truth, whole truth, nothing but the truth?
I do.
Thank you. Have a seat. Speak into the microphone, and you don't need to wear your mask while you're testifying.
Thank you.
Okay, and this is Mr. Crane, and he'll be asking you questions.
Thank you.
You're familiar with the evening this is about?
Yes.
Yeah, okay. When you came, did I swear at you at all?
Directly at me?
Yeah.
Not that I recall you were angry and yelling that day.
Did I thank you for coming and getting him off me?
I do not recall.
I know this is a long time ago.
It was a while ago.
Yeah, okay. Was it you that suggested putting the gurney at the edge of the porch so I could get on it?
Potentially, when I arrived, you and I spoke, and you were cooperative in being loaded onto the gurney, and we took care of your dog.
Yeah. Well, weren't you the one that came in the house and?
Yes.
Yeah, okay. Because I remember I was very happy to see you. Okay, you don't remember that. Did my dog, did he give you any trouble other than running from you? Was he aggressive to you at all, or did he just try to get to me?
I believe by the time I got there, the dog was actually in a room or somewhere else.
When you guys were chasing him down because he got out and tried to come to me?
I think he did get out a little later, and we ended up leaving him in the home and had food and water that we put out.
Yeah.
Yep.
But you didn't have any trouble?
I didn't have any issues with him.
No, he's not an aggressive dog. Okay, I know I remember specifically you telling Officer Gann that you thought he could get off of me.
Is this a question?
Are you asking a question?
Do you remember this?
I remember our interactions when I arrived. You and Gann were still on the ground. I began talking with you because you were angry, and at that point we were able to separate, and you were compliant on the ground at that point.
Okay. Thank you.
Mhm.
And I want to thank you that's all the questions I've got. Thank you for coming that day.
Thank you, Mr. Crane. Appreciate it. Go ahead and have a seat.
I don't have any questions.
Any questions? Okay, and may Bauman be dismissed?
You can be excused from
Okay.
my point.
You done with the
Oh,
deputy?
yeah.
Thank you, deputy.
Do you
Appreciate
need me
it.
for further down, or I'm done? I'm released.
Okay.
Released.
Thank you so much. Appreciate it. Okay, and is that your only witness that you're going to call to question today?
Well, since we couldn't get the 911 operator, he's the only other real witness.
Okay, and did you want to testify today?
Yes.
Okay, go ahead and come on up. Raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth?
I do.
Okay, go ahead, have a seat. Okay, go ahead. What do you want the jury to know?
Well, you've heard a lot of stuff about me, but I hope you noticed that they weren't real consistent on.
Object, this is a closing, not.
Okay, no, this
factual.
is your closing argument. Right now, you're just going to testify about what happened that night. What you're going into right now, that would actually be your closing, where you're actually putting everything together for him. Does that make sense?
Okay, yeah,
So do you still want to testify about what happened that night? Because you don't have to
Yeah.
testify.
yeah,
Okay, but remember, don't go into tying everything together, because that's going to be your close.
okay,
Does that make sense?
yeah.
Okay.
Thank you.
Okay.
When I got home, I was sick, and I had thrown up a lot and really messed up a back surgery. And I was in so much pain that I could only move a little bit at a time, because it just, across my back was just like a blowtorch was on it, and every time I moved, it would hurt so bad that the rest of my muscles would say, hey, you're hurting yourself, and they'd shut down. So I couldn't hardly move. I could crawl as long as I kept my head down for a little bit at a time. And I got to the phone and it wouldn't work. I didn't think I needed 911. It's just that was the only number the phone would dial. And they build them that way. They're automatic cell phone. You don't need to have a contract with anybody to use 911. If your battery's charged, you get 911. They do that on purpose because 911 is supposed to help. Well, they were also the only one I could call. And when they came, it was just, I couldn't believe it. I was sure they had left because I couldn't imagine any human being. That's what I told them. About my pills and stuff. A man on the street crossed somebody in this kind of pain would hand them their pills, whether it's his job or not. And I believe they came to the house. I don't know why, unless one of them's dating my ex-wife, why, but I believe when they came to the house, they were already mad or gonna set me up for something, because Officer Gann, when he was there, he stood at the end of that Davenport and he didn't say nothing. They said they told me this, they told me that, and they offered to help. They absolutely did not. When he came in, he stopped at my feet and said, what do you want us to do? I told him what I wanted done, or what I thought I needed done, and both times, nope, I can't do that. When I asked him, I told him, well, my pain pills, that's what I really need. I would like somebody to look at my back because I can't, but my pain pills, nope, that's not my job. And he would not, they were only like 10 feet away. They did not call my sisters to get me help that I needed, and I didn't ask them to after they first refused. They first refused, and then when I was threatening to sue them for trespassing and everything else I could think of, that's when he agreed. I don't know why, but just for something to do while I stayed there while I was trying to throw them out. I wanted them out. When he agreed to call my sisters, okay, I'll get a witness. My nephew, he's a big kid. He can come throw you guys out. That's when he called my sister. He literally woke up 2 sisters instead of getting me my pills that were just like in that chair there. And then the one sister, that didn't help situations any, because that just gave him ammunition to get at me. That's one of the reasons why I think they came there with that attitude, that they were going to, because they are experienced EMTs. I can't believe they treated anybody else this way, but they did me, and I think they had something against me when they came, because it don't make sense, the fences, everything. I did not hear them come in the back and holler that they were coming. I don't believe they did. They were in the house and through the house while I was on the floor after they did come in. But until that 40 minutes, they left me laying there, I think it was 42 minutes. And if I'd have been in the situation my sister was, I'd have laid there and bled to death. And they should, contact you and tell you why they're not coming in. They didn't say or do a thing. They sat out there until Officer Gann came. Officer Gann came, no problem, put my dog in the bedroom. Then he stood there and when I was wrestling with him, because my back, I couldn't lay the way he was wanting me to. I'm not sure, personally, you might think I'm really exaggerating. But when you've had that kind of surgery, that kind of stuff can either paralyze you, possibly kill you. It's not beyond the realm. And I was convinced that's what he was trying to do. He was either going to cripple me or kill me, or he was certainly going to make it, so I had to go to the hospital. And they accomplished that. After the deputy sheriff came in, got him off of me, we talked, no problem. He talked to me nice. I thanked him for talking to me nice. They not once did. They came in mad, they stayed mad, they were madder than me. And when the sheriff come in, he asked me if I wanted to go. And I told him, well, they finally beat me until I need to. Yes, I think I ought to go get it looked at. And so I crawled out across the porch, and it's a little raised, so they had the gurney down, and I just crawled to the edge of the porch and rolled into the gurney and went to the hospital. While they was loading me, my dog got out of the house and came around, and I petted him and tried to calm him down, but Kirk wasn't scared then of him, because when I went to pet him and calm him down, Kirk again used his legs and shooed my dog off and wouldn't let me calm him down. But to be truthful, I was half in the ambulance, so. But anyway, he wasn't scared of the dog then at all. And as far as the bedroom door, I had not even considered Rex being in there. I forgot, I was just in such pain, I wanted to go to bed. I had finally gotten my pain pill, I wanted to go to bed. They would not let me go to bed. They wouldn't leave, they didn't tell me why, they never gave me any idea that they thought they had a reason. When they got me to the hospital, the doctor at the hospital looked at my back, told me it looked fine, asked me how I felt. I've got chronic depression and anxiety problems. And that's one thing they did, was they just wrapped my anxiety up so high. So I didn't need a pain pill. At the hospital, I didn't even take a pain pill, because the other one was kicking in pretty good by then. So I was fine pain-wise. He gave me a Xanax for my anxiety and sent me home in the taxi. I could take care of myself just fine. There was no reason, if they'd have looked at my back and told me it looked good, or didn't see anything obvious, I wouldn't have gone with them then. But nobody would even look at it. So after that wrestling match I took from the officer, I thought the doctor should look at it. And he said it looked fine. I was feeling a lot better from the pain pills, so he gave me a Xanax and sent me home. I got home, I went to bed. Next day, the phone had charged up. I called my brother, him and his sister, him and his wife came and got me food. They bought a chicken on the way and stuff, and got me food that I could eat without having to stand up and fix. And so my family will help me, except one. And I blame myself there for ever getting back involved. But I don't know if you call a family relative and ask for help, what you would say to them if you heard them say, I can't think of anybody I'd call to help him. I mean, I stand by what I said. That was because I'd have been, if she'd called me in the middle of the night, I'd have known it was something important, and not the first thing out of my mouth was, where are you, and how soon can I get there? So yeah, it's, that came to a parting of me and my sister again, so out of their coming to the house to harass me, for some reason, I had lost a sister and all of this. He didn't file this until after I filed a complaint on him. They didn't get the arrest stuff from him, I believe, until after I'd filed a complaint on him. This is retaliation for me complaining about what they did. And it just, I mean, please think of your relatives or yourself if you're on the floor in such pain. And swearing does help. If you go strict by that law that he read, my wife, when we had our daughter, she was in labor for like 14 hours. And there was other women coming in and out. And my wife, she wanted to go over and beat up one of them because she couldn't stand listening to her. But some of them women, they would cuss and they would threaten to do things to their husband that unmentionable. But you're not going to call that, you know, disorderly, or, you know, they understand it's the pain and stuff that's going on that's making her do that. And I'm not saying, I have no idea, I can't imagine how that must hurt for women to do that. But I can't explain how much I was hurting either. And so, yes, I swore a lot. I didn't know they were out there. I thought they'd left me there to die. In fact, I told them that. And so, yes, I swore a lot. It helped the pain. All I wanted was to help the pain, and then when I got a pill, to go to bed. That's all I needed. Instead, I got a beating until I needed to go to the hospital. That is what happened. I don't know why. I can't explain, but I would like to know why. But other than they've been listening to my ex-wife, that's the only thing I can think of. But they came to the house to do something to me. And I'm sure of that, because this whole thing is just all put up. I'm sorry if it offends you guys, but I've sat there and listened to so much lying. And it is just, you've been lied to.
Okay,
Objection,
remember,
this is
listen, no, listen. It's your testimony, it's not your closing. So you're not talking to them right now about
I'm
lying or what the other, so it's just about your testimony.
I'm sorry.
No, you're okay.
Get on a roll.
Do you have anything else you want to tell them about what happened that day or that night?
No, that's pretty much, I was the one assaulted.
Okay,
And I went to the prosecutor's office to try to press charges. They told me they don't take walk-ins, that I had to go through the sheriff, or Castle Rock chief of police. I'd already done that. He claimed he interviewed me. He called me a couple times to talk about somebody else investigating the situation, but he never got my full story, and I didn't know when he called that he was going to consider that the interview. So he he put down that he interviewed me and this was his decision, that they didn't do anything out of policy. When a man's down crippled, what policy says jump
Objection,
on
this
his
is more
back?
of a
Okay,
closing.
again,
Right. I'm
again, do you understand the difference?
sorry. Yes, I just can't haul. I'm trying to think at the same time. It don't work.
It's okay. That's what I was
Okay.
telling you. It's not gonna be easy, but you're doing it. But it's just about you testifying about what happened to you, okay? You're gonna get an opportunity to close.
Well, I've pretty much said what happened.
That's your
so,
testimony, okay?
Yeah.
So now remember what I told you? Now the prosecutor can ask you questions.
Yeah.
And I want you to just focus on what he's asking you and answer him, okay? Okay,
I'll try.
Okay. Your Honor, may I approach the defendant?
you
Oh,
may.
yes, I want to.
Now, Mr. Crane, you have a bunch of exhibits that you wanted the jury to see, correct?
Yes, I forgot about that.
That's okay. So, I'm handing you, sir, exhibit marked as number 1. Do you recognize that picture?
Yeah.
Did you take that picture?
Yes.
What's it a picture of?
The pole lamp is not the one. I took this picture after I found out that he was pressing these charges. So the lamp had been changed. Otherwise, everything's the same.
Okay.
But it's basically the same lamp.
Okay, do you want to admit that picture into evidence?
Yeah, I put a cane down here.
Okay, hold on. So you want to admit it to evidence?
Yes.
Okay, Judge, the defendant wants to admit that to evidence.
I'm gonna allow it to be admitted.
Okay, all right, so you can talk about it in closing.
I put the cane down there just to give an idea of size of the room,
Okay,
where I was and where he was at the door.
Okay, and you took this picture, exhibit number 2, is that correct?
Yes.
Is it fairly and accurately depict what the room looked like on the day in question?
Yes, except the pole lamp was black and this one's white.
But it was a similar pole that you grabbed?
Yeah. Same size and everything.
Okay, do you want to admit exhibit number 2?
Yes.
Okay.
so admitted.
And I'm handing you what's been marked as your exhibit number 3.
See, that shows the Davenport that I was laying behind,
Okay.
and the phone has been put back up on the shelf.
Other than the phone being put up on the shelf, is that how the room looked?
Yes.
Do you want to admit number 3?
Yes.
Admitted.
And I'm handing you what's been marked as defense exhibit number 4. You recognize that picture?
Yes. I didn't have anything, so I took my clothes on your folding clothes holder and hung a shirt on it and a hat on it for Kurt. And this, I wanted to show,
Where he was
where he
standing?
was at and where the pole lamp was at.
Okay,
I couldn't get where I was laying.
all right, you want to admit number 4?
Yeah.
Okay.
Admitted.
And number 4 actually is the shirt you're wearing today, correct?
I guess so.
Yeah. All right. And that's supposed to be where Kurt blocked into the room, right?
Well, actually, when he blocked me, he stepped over in front of the door. That's where he was standing when I crawled in front of him and went around, and I was reaching for the door handle, and that's when he leaned into me. So I was only on one hand and
Not
my
like
knees.
this, like he was kind of like this, but the
Yeah, and
Okay.
that's why I fell over so easy. I didn't have good balance. I was reaching for
And
the.
that's supposed to be Kurt, your shirt and that hat.
Yeah.
And handing what's been marked as exhibit number 5. You recognize that?
See, that just shows the area that I was laying, and there's a rolled up
Okay.
area rug. I was using that for a pillow.
Okay, and does it accurately depict what happened
Yes.
that day? Do
Yes.
you want to admit number 5?
Please.
Admitted.
And I'm handing you what's been marked as your exhibit number 6. You recognize that?
Yeah, that didn't come out very good, and when I had them enlarged, I tried to brighten it, but it didn't work. That shows for the pole lamp, and I moved the shirt over to where Officer Gann was standing. And, I guess I'll explain that later. I would like that exhibit.
Okay.
Admitted.
Admitted, thank you.
And the pole lamp, you actually intentionally grabbed it, right?
Yeah.
You grabbed it, but you did it on purpose,
Yes,
and you picked it up,
yes.
and you swung it.
No, I did not pick it up. It was standing on the ground. I was actually,
Did you swing it towards Huda?
I rocked it. What
Yeah.
I did, you could not call a swing. I
So
didn't
you
have
rocked it towards
I
Huda.
rocked it,
You rocked it, you did it to get him to move.
yes,
And you did it to scare him to move out of your way.
yes.
And you were mad that day, right?
Not until they left me to die.
But you were mad that they didn't come in your house when they had heard your dog barking, right?
My dog barked once.
Okay, and it's a pit bull, correct?
Yep.
And it's about, what, 60 pounds?
Closer to 75.
All right, 75-pound pit bull, they hear barked and they bail out.
Yeah.
And when they bailed out,
If they were,
a dog that they didn't know, right? That's a 75-pound pit bull, and they hear it barking, and they left in that situation, and you were upset that they didn't stay and help you, correct?
Yep.
And that made you mad, and so you called them names and you yelled at them, right?
I called them everything I could think of, but
Right, and
I can't think of the stuff they put down.
and you were mad when you called your sister and she wouldn't come help you, right?
Right,
And you were mad when you couldn't get your pills, right?
right.
And you were mad when Huda blocked your access to your room where you just wanted to escape, right?
More than mad, I was disgusted.
Okay. I don't have any further questions, Your Honor.
Okay. Okay, you're done with your testimony. So go ahead and have a seat.
Okay. Thank you.
You're welcome. And you don't have any other witnesses here today, right?
No, the only one I had was the 911 operator, and she can't come much.
Okay. So right now, what we're going to do is we're going to go ahead and close your case. You testified and you had your witness, all right? Okay, so the state had their case, you had your case. Are there any rebuttal witnesses at all?
We're not calling any rebuttal witnesses, Your Honor.
Okay. Okay. Then that should conclude the case as far as the state and the defense. Now, does anybody need a break, or are you all still good?
Okay.
Everybody okay? Okay.
Excuse me, I'll still get a chance to make a statement, my closing.
Absolutely. You are going to, yes, you're going to get a chance to do your closing.
Okay, thank you.
What we're going to do now, though, is I am going to go ahead and actually, should we take a break so we can go through the instructions, or do you want me to just go through them?
I think the instructions are fine.
Okay. What we're going to do now is, remember when I was telling you at the beginning, you're going to get the law to take back with you? What they actually are, they're jury instructions. So what's going to happen now is I'm going to read them to you. It's going to take me a few minutes to go through them, but you're actually going to take them back with you when you go back to deliberate, all right? So I'm going to read them to you, and then we're going to go ahead and we're going to have the closing. So that's kind of where we're at. We're making good time. And like I said, don't worry about memorizing these now, because you'll be taking a copy back in there with you. Each one of you will have your own copy, all right? Okay, this is the first instruction. It is your duty to decide the facts in this case based upon the evidence presented to you during this trial. It is also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proved, and in this way decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during your deliberations consists of the testimony that you've heard from witnesses and the exhibits, which would be the pictures, that I have admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the court clerk and given a number, but they do not go with you into the jury room during your deliberations unless they've been admitted into evidence. And I did admit all of the pictures into evidence. So they will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings on the evidence. If I have ruled that any evidence is inadmissible, which I did not, or if I have asked you to disregard any evidence, which I did not, then you must not discuss that evidence during your deliberations or consider it in reaching your verdict. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all of the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given the testimony of each witness. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things he or she testified about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest or bias that the witness might have in the outcome on the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in context of all of the other evidence, and any other factors that affect your evaluation or belief in a witness or your evaluation of his or her testimony. The lawyer's or Mr. Crane's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It's important, however, for you to remember that their statements are not evidence. The evidence is the testimony you heard and the exhibits. The law is contained in these instructions that are going to be given to you. You must disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. You may have heard objections made by the lawyers during trial. Each party has a right to object to questions asked and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on any objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express by words or conduct my personal opinion about the value of testimony or other evidence. I have not intentionally done this. If it appeared to you that I've indicated my personal opinion in any way, either during trial or in giving these instructions, you must disregard this entirely. You have nothing whatsoever to do with any punishment that may be imposed in case of a violation of the law. You may not consider that punishment may follow conviction except insofar as it should make you careful. The order of these instructions has no significance as to their importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions. During your deliberations, you must consider the instructions as a whole. As jurors, again, you're officers of the court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proven to you through the evidence and the testimony and on the instructions. You may not base your decision on sympathy or prejudice or personal preference. To ensure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. The defendant has entered a plea of not guilty. That plea puts into issue every element of the crime charged. The state is a plaintiff and has a burden of proving each element of the crime beyond a reasonable doubt. The defendant, Mr. Crane, has no burden of proving that a reasonable doubt exists. A defendant is presumed innocent. That presumption continues throughout the entire trial unless, until your deliberations, you find it has been overcome by evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists, and it may arise from evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If from such consideration you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has direct personal knowledge of something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts of this case. One is not necessarily more or less valuable than the other. To convict the defendant of the crime of assault in the 4th degree, each of the following elements of the crime must be proven beyond a reasonable doubt. Number 1, that on or about April 10th, 2020, the defendant assaulted Kirk Huda. And number 2, that this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proven beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all the evidence you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. An assault is an intentional touching of another person that is harmful or offensive, regardless of whether any physical injury is done to the person. A touching is offensive if the touching would offend an ordinary person who is not unduly sensitive. An assault is also an act done with intent to inflict bodily injury upon another, tending but failing to accomplish it, and accompanied with the apparent present ability to inflict the bodily injury if prevented. It is not necessary that bodily injury be inflicted. An assault is also an act done with the intent to create in another apprehension and fear of bodily injury, and which in fact creates in another a reasonable apprehension and imminent fear of bodily injury, even though the actor did not actually intend to inflict bodily injury.
Your Honor, if we could just go back up to the 2nd paragraph, I believe that a not was not put in to if not prevented.
If not prevented.
Yeah, in the end of the 2nd paragraph.
An assault is also an act done with intent to inflict bodily injury upon another, tending but failing to accomplish it, and accompanied with the apparent present ability to inflict the bodily injury if not prevented. It is not necessary that bodily injury be inflicted. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. A person knows or acts knowingly or with knowledge with respect to a fact, circumstances, or result when he is aware of that fact, circumstance, or result. If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted but not required to find that he acted with knowledge of that fact. Bodily injury means physical pain or injury, illness, or an impairment of physical condition. As jurors, you have a duty to discuss a case with each other and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence in these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors. Nor should you change your mind just for the purpose of reaching a verdict. When you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard in every question before you. Deliberations are to occur only in the jury room when all 6 jurors are present. You are all officers of the court and must evaluate the evidence with an open mind, free of bias or prejudice. If during your deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During your deliberations, you may discuss any notes that you've taken during the trial if you wish. You have been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during your deliberations. And again, remember, you're not going to have any tapes to take back. If after carefully reviewing the evidence and instructions, you feel a need to ask the court a legal or procedural question that you've been unable to answer, write the question out simply and clearly. In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to the clerk. Then I will confer with the parties out here to determine what response, if any, can be given. You will be given the exhibits admitted into evidence, these instructions, and a verdict form for recording your verdict. Some exhibits and visual aids may have been used in court, but will not go with you to the jury room, and that's not the case here. The exhibits that have been admitted into evidence will be available to you in the jury room. You must fill in the blank provided in the verdict from the words "not guilty" or the words "guilty" according to the decision that you reach. Because this is a criminal case, each of you must agree in order to reach a verdict. When all of you have so agreed, fill in the verdict form to express your decisions. The presiding juror must sign the verdict form and notify the clerk. The clerk will bring you into court then to declare your verdict. And then the last page that I have is the verdict form. So these are the instructions. You're going to take these back with you. I know it's a lot of words, but you will have them right in front of you. And right now we're going to go into closing arguments. Is everyone ready for closing arguments? Okay, so the prosecution is going to start. The state.
Good afternoon. When we started this morning, I told you this would be a case about the defendant swinging a lamp towards Mr. Huda, and that's exactly what he did. Not only did Kirk Huda tell you that, Ms. Pop told you that, Officer Gann, who was there, told you that, but the defendant told you that. So we have not a situation of he said, she said, but a situation that they all say that that act happened. And there's some things that Mr. Crane wants to dispute, and there's some situations that he wants to explain, and some difficulties and some challenges that made him really mad. And those things exist. But what isn't controverted is that a lamp was swung by his hands towards Mr. Huda's upper chest, torso, and face. And that's an assault. It's not really in dispute whether he actually committed the crime of assault. And so it's really challenging. It's like, well, where's the dispute? Well, on the legal issue of an assault, there is none. On whether he felt like he got the care that his mom got from EMTs in the past, that may be disputed. Whether they should have been more brave around his pit bull, that could be disputed. Where there was a bummer that he contacted the sister that doesn't like him, that could be in dispute. It would be nice if he would have got a hold of someone that would, a sister that would have been nice. Those things are in his defense and problems that he has with the situation. But the actual fact of an assault happening is agreed. And she's testified to it, that he grabbed it with the intent because he was disgusted with Mr. Huda. He was disgusted. from his standpoint, he's in pain. He's hurting. He's dog that he loves. He knows the dog's friendly. So from his standpoint, it doesn't make sense what Huda and Pop did. Huda and Pop respond to a call. They don't want to be out there at 11:30 at night. And the call is, we've got someone that has back pain and they need to help them. And they go enter the back door and there's a pit bull that they don't know that comes barking and chasing at them. They're out of there. You know, we'd really like to help you with your back, but you know, I'm not going to get attacked by a pit bull right now. Nor should they. And nor should they have a lamp swung at their face because things aren't going the way that the defendant wanted them to. Because he was disgusted with the service he was getting from the EMTs. And so when you go back to deliberate, you know, we talked about, well, what's a reasonable doubt? If you have an abiding belief in the truth, then you don't have a reasonable doubt. So the instructions tell you what reasonable doubt is. If you have an abiding belief in the truth that he intentionally swung that lamp towards Mr. Huda to get, because he was disgusted with him, then he's guilty. And looking at the instructions, there's some that kind of jump out at me, and you get to evaluate the law and the facts. But one that I think is very interesting in this case is that you have nothing to do whatsoever with punishment that may come. A lot of the defendant's arguments are really about whether there should be punishment, not whether he actually assaulted Mr. Huda. It goes on to say that sympathy or prejudice shouldn't impact your decision. Anyone can feel sympathy for having a back surgery. It's tough. He's in pain. He didn't have anyone taking care of him. He had equipment problems. His house doesn't have the numbers on the outside. He can't access his medicine. He doesn't know how to get to it. His phones are dead. He doesn't have his access to charging up the phones. Like, he's got all kinds of different equipment problems going on. His hearing aids aren't working. He can't remember people's phone numbers. He's already frustrated. He's in pain. And that's rough. But it doesn't mean he didn't assault Mr. Huda. It means that at the end, when someone may, if you guys find him guilty, sentence him, that a judge may take into consideration all those factors. But it's not an issue of legally, Mr. Huda wasn't assaulted when he swung that lamp on him. And so sympathy doesn't come into the courtroom. What comes into the courtroom is facts and evidence from the jury, and your verdict is the truth. It comes down from England. Verdict means truth. And if you have an abiding belief in the truth that he swung a lamp at Huda and scared Huda with that lamp, the defendant is guilty. When you look at the to convict instruction, which is in your package as well, we call it the to convict. It'll have state's got to prove this beyond reasonable doubt and that beyond reasonable doubt. I normally talk about bases in a baseball field. And we got to prove that he got the first, and then we prove the second element, second base. Well, there's only two elements on the assault form. One element is that the acts occurred in the state of Washington. So you've probably heard me ask several witnesses, where was this? Castle Rock, what county? Cowlitz, what state? Washington. And that's not a factor. It obviously is proven that these acts occurred in Cowlitz County. The second was that on April 10th, 2020, the defendant assaulted Kirk Huda. Did he assault him? So when you're looking at that, you can look at the direct evidence or circumstantial evidence like we talked about in jury selection. And circumstantial evidence are the circumstances around that would lead a reasonable person to make reasonable inferences. And the circumstances was that he was angry. He was swearing. He was swearing at the EMTs when weren't coming in the house to help him because they were afraid of the dog. He was swearing at him when he was having problems with the phones. He was swearing at him when he was getting blocked or where he wanted to go and what he wanted to do, which would have opened the dog that would have let the pit bull out of his bedroom. So it's understandable that they did what they did. And it's understandable in a lot of ways he's upset about certain things. But the circumstantial evidence is he is angry and he is mad. And he grabbed that lamp and swung it towards Huda, and Huda avoided it and moved, or it would have hit him in the upper body, upper face. And so when you look at, well, is that an assault? We give you a definition of assault. And the two that I would focus on are that an assault is an act done, and I'm trying to talk with these masks, but I'm trying. An assault is done with an act done with intent to inflict bodily injury upon another, tending but failing to accomplish it, accompanied by an apparent present ability to inflict bodily injury, if not prevent it. It is not necessary that bodily injury be inflicted. So when you swing a lamp at someone and you intend to inflict bodily injury on them and they move, it's an assault. The fact that it didn't hit Huda, the fact that Huda saw what was happening and moved out of the way and didn't get his eye taken out by glass broken from the light bulb, doesn't not make it an assault. If the light bulb would have torn his cornea out and he would have ended up in the hospital, then we'd be talking about probably an assault 2 or an assault 1. But he moved, and the lamp and the object did not hit Huda. But it doesn't mean it's not an assault 4. It's an assault 4 because he even admits that he grabbed it and took it towards Huda. The second part of assault that I think is important is the one where it talks about assault as an act done with the intent to create in another apprehension and fear of bodily injury. And that's the one that we talked about in jury selection. Someone just intends to scare me and fake punch. And I'm like, whoa, that's an assault. Because mentally, emotionally, I thought I was getting hit. And you intended me to feel like I'm getting hit. And so the defendant's act of taking the lamp, which is a large object with glass on it, and swinging it towards Huda, was an intent to create that apprehension and fear into EMT Huda. When you look also at bodily injury, it's defined. It's not you're intending to kill somebody. It's physical pain or injury, illness, or impairment of a physical condition. If you get hit in the face and the upper body with a lamp, it's going to hurt. It's going to cause physical pain. So when you look at those elements, you look at the law and you look at the facts, the state proved this case not just beyond a reasonable doubt, but beyond all doubt, that he assaulted Mr. Huda, that he did so because he was disgusted and he was angry and he didn't get what he wanted to do and it was unlawful. And so I'd ask that you find him guilty of assault in the 4th degree.
Thank you. Now's your time for closing argument.
Okay, thank you. Well,
And you can also show those pictures if you want.
oh, please. Thank you. Well, heard a lot of stories and stuff about what happened, but I guess mine is the only one that makes sense to me because I was there. So if I'm really asking you guys to decide whose story you're gonna believe. And to me, if I wasn't telling the truth, why would I go through all this? I'm going through all this because those people came into my house, the sanctity of my home. They trespassed. If you go strictly by the law like he wants to, I bet everybody in here should have been arrested at one time or another. And him keeping me out of my room. Even if it was my house, it was my room. As far as I'm concerned, and by the law, it's assault for him pushing me down, which he definitely did. I mean, he put his leg when he says he stepped in front of me to block me. Well, maybe he didn't do it intentional, but when he stepped in front of me, he stepped into me, which knocked me down. That's assault according to that. The premise that I started cussing at them as soon as they got there, why would I have done that? I don't cuss at people for no reason. I was hollering for help because the number is on the house. I don't have any trouble getting my mail. Everybody else finds it, but it's not by the door. And so that's why I thought, you know, maybe they were looking for the house number, so trying to light. Cause I did see a flashlight on the front window. That's how I knew they were there. My dog barked once. I know a lot of people are scared of pit bulls. That's why when he barked once, I called him right to me and told him, "You gotta be quiet. You're gonna scare him if you bark. Don't bark." He did not bark no more. He barked one time. At the time they say they came in, if they came right in when they got there, my dog was still wrapped in my arms and I was talking to him. I did not hear anybody announce anything. That's why, and I put it in the complaint against them and everything, that they left. I thought they were gone. So, there was no knowledge that I was assaulting them with cussing at them and telling them my opinion, because when you're in that kind of pain, it helped. The officer said he was standing in front of me when I swung the lamp. Well, this one picture is a real dark one, but it shows the Davenport, the arm, and I put that homemade mannequin where Officer Gann was standing. He says he was standing in front of me at the same time I swung the lamp at Coda and he grabbed it. Impossible. If he'd have been standing beside or in front, you wouldn't have been able to tell. They would have been shoulder to shoulder. You wouldn't have known who I swung it at, whether it was Kurt or Gann, if you go that direction. He was not standing in front. He was standing behind where he was the whole time while Kurt harassed and berated me, and he was standing there now. I didn't know at the time, but after giving everything so much thought that I have, I believe he was standing there with the intent of Kurt provoking me into what I consider self-defense. They were in my house. I ordered them out. I told them they were trespassers. They never explained anything to me about why they were there. They just wouldn't leave. They were trespassers. It was unlawful imprisonment or something in that term I know, when they wouldn't let me go into my own bedroom. They kept me in the living room. No reason for that. The dog was in there, but Officer Gann had already put the dog up. It had been determined that that dog was not going to bother anybody. They knew that. They didn't have to keep him out of his bedroom because of the dog. He was not in there barking. He never made a peep. That's why I tried to get the 911 recording, because it would have on it that the dog didn't bark. But I didn't know that they erased them. I thought since it was a court open case that they would keep stuff like that. But they got it on the machine, I guess, at a certain time. So many months go by, they erased the tape. They told me I missed it by 2 days. If I could have got that, or the operator as a witness, they could tell you that she did not hear the dog barking. That I hollered for help more than 5 minutes. I hollered for help until I was hoarse. After I rested from that is when I started cussing. And I thought they had left me there to die. And from what it felt like to me, and knowing my sister almost bled to death, at first, I was a real concern. But then as things gone by, before they came in, I decided, I'm still alive, I guess I ain't bleeding to death. So, when they come in with that attitude, I mean, he just walked in there and said, "What do you want me to do?" And when I told him, no. He wouldn't give me my pills because it wasn't his job. He did when Stacy, one of them, I can't remember now which one, said that they're not allowed to disperse medicine. He didn't give me the bottle. She gave him the sack. He opened it, he took the pills out, he looked at it. He read how many I was supposed to get. He took it out, opened it up, and took out 1 pill and gave me 1 pill. And and then he put the bottle on the table by the chair. So, they do dispense pills. He didn't give me the whole bottle, he gave me a pill, finally, after I had told him, and that's why I say disgust. I consider their behavior disgusting. They come into somebody that's just had back surgery into their spine, and if they thought I was a danger, they had the whole house. Why couldn't they have just stepped away? No, he had to jump on my back and twist me around and hurt me. And I fully believe that that was their intent. I know my ex-wife has talked to the sheriff and other people, telling them all kinds of stuff, but even if so, they shouldn't believe an ex-wife. And even if they do, they shouldn't sit out there for 43 minutes from the time they got there, and that, I don't know how long Officer Gann and them talked out there. Because on the chart, that says when they arrived and when Officer Gann arrived, and that was 43 minutes apart. So they were out there at least 43 minutes. They did not come to the front door. If they'd have told me, Rex would have went into the bedroom, because he ain't got in trouble for a long time. But when he'd leave the yard, if I'd let him out with me when I'd go out to the side, it wasn't fenced. He's not supposed to go out into the road. And when he would, if he kept doing it, that's where he went for a timeout, was in the bedroom. He might have been a little confused on what he had done wrong, but if they'd have told me, it would have taken me a while to get to the door to close it, but if it would have meant getting help or not, it wouldn't have taken me 40-some minutes to get to the door and close it behind me. And Rex would have went right into the bedroom. I wouldn't have had no trouble locking him in the bedroom myself. Well, I would have, because it would have taken me a while to call back, but I mean, Rex would have went right in the bedroom. They did not come to the front door and ask for anything. Stacy Puff. I was really hoping for her to tell the truth, because I didn't think she was in on it, really. She was clear back at the door. I could hardly see her, and I couldn't have identified her when she came in, because either one of them actually, because I couldn't lift my head up. People look different when you're laying down on the ground looking up at them. But she was back there, and she really had no part of it. That's why I thought she was back there because she knew they were doing something they shouldn't be. If she stood up back there by the door, had no part of it, I don't give her a complete pass because she didn't leave. I told them, get out of my house. She didn't leave either, but she wasn't parading me. It was Kurt that was, I couldn't remember my relative's phone numbers. Oh, what's the matter with you? You can't even remember your brother's number, and stuff. Oh, yeah. And then especially after my mom said I can't think of anybody I'd call to help him. Oh, at least 3 different times, I believe more, he said, your own family won't help you. First thing my brother said when he found out was, why didn't she call me? But he just had to go clear from Longview. Her son, he's just a few miles away. But that's what I told Kurt I wanted, but he wouldn't tell her that. He wasn't telling them anything that would get me help. He was telling them I wanted help, but I wanted somebody to come stay with me. I didn't want nobody to come stay with me. I wanted everybody out of the house after I got my bill. It was just an episode I'll never forget, and I tell the neighbors and everything that I'll never call 911 again, because the fire chief, he said that was absolutely right. That they're a transport company, not a service company. So his only job was to take me to the hospital, whether they had to beat me to it or into it or not. And he said, I told him, well, they didn't leave. I told them they were transport trespassing. He says, well, you were upset, so they couldn't leave while you was upset. She's darn right I was upset. They were the ones upsetting me. If they'd have left after I got my pill, I'd have gone to bed and gone to sleep. But no, they wouldn't leave. They wouldn't tell me why. They did not talk to me like they say there. That's what I told Officer I want to say Sherman. That's not it. Anyway, the sheriff that was here. That's what I told him when I got here. When he came in, I told him, you're the only person that's talked nice to me all day. But it was just, I know it sounds outlandish, but that many people came in, paraded through here with complete fantasy. And you can see by his representation, I couldn't get up. They exaggerate what little was correct. Swinging that lamp, I would not call what I did a swing. It was just a rock. I could not hardly move. It hurt to breathe. I was not, especially with two hands swinging something, I was laying on the ground. I rocked it towards him, and not immediately after he pushed me down, because I couldn't get up immediately afterwards. We argued a while, and I worked up enough nerve that I thought I was going to try to get up and make a deal, run for the door, if I could get him out from in front of me. So I did rock the lamp towards him. I rocked it. I did not swing it. One hand, it never left the ground. He couldn't have grabbed it, the Castle Rock cop, from the back of the chair until after I pulled it back and was trying to land on it because I was trying to get up. I thought I was still going to make a run for the door. Then all of a sudden he reaches over me, grabs the lamp and gives it a yank. He pulled the weight of the base into me, is why it broke, because he couldn't pull it through me. That's why it broke. And the whole time he was standing back there, and now I fully believe he was just standing there that whole time waiting for Kurt to get me to give him an excuse to jump on me. And any man that would jump on somebody that can't even get up, having trouble even breathing, instead of just stepping back, that's, to me, that's disgusting. That's why I say I was disgusted with them. That if I would not want them to come to any of my family, they are just, well, we had a whole parade of what I consider despicable people. And so now I'm going to have to ask you to decide if they're more despicable than me. And I'm telling them the truth. That's all I can say is. And the pictures, I just took them to show what the area was like. When you see this picture with this pole lamp, the difference is this one's white, the one he broke was black. There's not really room to swing that like that. You just, I couldn't get the phone down. I had to pull it off the shelf by the cord. There's just no way I was a threat to them. And so the pictures here, I put a cane down on one just to give you an idea of the size. And it wasn't this cane, but it was one of my other ones, same size. And so you can see in the picture that Kurt was about that far from me. So if I would have been intent on hitting him with that lamp, it was harder for me not to hit him than it would have been to hit him. So it don't even make sense that if I tried to hit him, it missed. I admit, if they call that 4th degree assault, I admit I did rock it toward him with the intent of getting him to step out of the way of the doorknob. But under the circumstances, when you're being trespassed, when you're being held prisoner in your own living room, I don't think that calling that 4th-degree assault is what the people that made that law ever dreamed would come up with it. It just, that's not assault, but if it was self-defense. Because they came in and just, I mean, I just couldn't believe it. They were just harassing me and demeaning me, and now they're doing this out of retaliation because I complained. The EMTs should not be allowed to go to people's house. The cop that jumped on my back when all they had to do, he's going to shoot somebody someday. That's one thing that scared me when they started chasing my dog, and I did all of that because I was afraid he was going to shoot my dog because I couldn't catch it. So when they were loading me in and chased the dog off, I was hollering, "Don't shoot my dog!" Because I thought anybody that jumped on a man's back in those circumstances, he's not going to hesitate shooting your pet. That's, they just disgust me. And now that the rest of them come through, I'm pretty disgusted with the whole bunch. I just hope you understand that they didn't show any proof, and in fact, they're exaggerations. They told different stories on how I saw it. They told several different versions, just little bits of what happened. So they didn't prove anything except they've got a story and I've got a story. And if I was lying, why would I come in here and go through this? It's a disgusting situation, and that's all I've got to say. I just pray you guys will take my word for it, not theirs. I know they outnumber me, but they knew that when they was doing it.
I'll take it.
Thank you.
Thank you, Mr. Crane. Go ahead and have a seat. And finally, the state gets a final argument.
So Mr. Crane doesn't want us to go strictly by the law. And those were his words. He's like, he wants you to go strictly by the law. And I just do. That's what the law says, is that we strictly have to follow the law. And when you strictly follow the law, and you swing or rock or scare somebody with hitting them in the face with a lamp, you're guilty of an assault. That's what strictly by the law is.
Kalisha.
When he talks about
You have to
the fact that Mr. Huda, when he moved to not let the dog out of the bedroom, there may have been some bumping, and he claims it's an assault. Well, that's not an assault, because you have a definition of assault. Okay? Your definition of assault is an intentional touching of another person that's harmful or offensive. So your own testimony was that it was some kind of accidental touching between Mr. Huda getting to block the door and you crawling to try to get into the room. That was what he said. It wasn't like he intentionally, there may have been some slight contact. That's not an assault. It's accidental touching. And you testified to that, but neither of the EMTs testified to that. And his own testimony was, it was an accident. It wasn't like he was trying to harm you. They were there doing their jobs to provide aid. They couldn't leave because he couldn't take care of himself, and they couldn't get any of his family members to come to take care of him. When he went to open the door where the pit bull was, Mr. Huda appropriately blocked that move. In response, the defendant tried to swing a lamp, rock a lamp towards Mr. Huda. Mr. Huda's actions of moving out of the way is circumstantial evidence that shows you he believed he was about to get ready to get hit by a lamp. The defendant's admission that he did that so he would move out of the way of the door is an admission that he did that to scare him to move out of the way of the door. The officer's actions of grabbing the lamp, because the lamp was being used as a weapon, is circumstantial evidence that that was assault. The officers arresting him and getting control of him is circumstantial evidence to show that he just committed assault in everyone's presence. Everybody knew there, all four of them, that he had assaulted somebody. He did it with his own purpose and his admission in the stand. All three other people immediately recognized it as an assault. We'd ask you to find him guilty. Thank you.
Thank you. Okay, that is going to conclude the case for today. And just one second. So do you want to bring the instructions into them in the room, or what do you want to do? Yeah, okay. Okay, so the bailiff is now going to escort you to the jury deliberation room. We're going to bring in a copy of the instructions in the verdict form. And you are going to go in there and you are going to select one person to be the foreperson, and they are going to deliver the verdict to the court. There's no requirement to be selected foreperson, and that is your sole decision among the six of you. And any exhibits will also be admitted into the room, so you're going to have the instructions, and you're also going to have the photographs, and then you can begin deliberation upon your verdict. So go ahead and take them back to the